the Latin phrase, which means the entitlement to be heard. The fact that, in her view, there was procedural irrationality, the right to legal representation. The rules don't allow her legal representative to actively participate in the committee. The rule against retrospectivity. This had to do with the fact that these rules were adopted after the conduct in question, issues related to the recusal and conflict of interest, the right to independence and separation of powers. This matter was also heard together with another application that was brought by Democracy in Action, which is a civil society organization, and they raised very similar concerns, hence the two matters were then heard together. The PP was not successful in securing that interdict in Part A, and the legal effect of that is that unless and until those removal rules are declared unconstitutional, the Assembly may continue with its inquiry. Part B, which was on the substantive issues and deals with the actual review of the process and the constitutionality of the rules, was heard in early June of this year. We are still awaiting judgment in that matter, and as it currently stands, we have no indication as to when judgment will be handed down. In terms of the legal framework, the process for removal is governed by two legal instruments. The Constitution, firstly, and then secondly, the so-called removal rules. In terms of the Constitution, Chapter 9 heads may be removed on grounds of misconduct, incapacity, or incompetence. In our case, the motion deals with misconduct and incompetence only, doesn't deal with incapacity. Removal of the Public Protector and the Auditor General requires a finding by a committee of the NA and a supporting vote of at least 2/3 of the members of the NA. So it's important to note here that the threshold for removal of the Public Protector and also the Auditor General is higher than that of other Chapter 9 heads, which just require majority vote. And it's clear from the certification judgments that the incumbents have a special protection because of the nature of their roles, which often involves the investigation of high-level officials and controversial matters, which of course may have adverse political consequences. As such, the removal threshold is therefore higher. The President may suspend the Public Protector, and that's entirely at his discretion, at any time after proceedings of this committee has commenced, but must remove the Public Protector if the NA so resolves. Chair, I just want to mention that the basis for removal, so incapacity, misconduct, and incompetence, can obviously only be properly understood against the backdrop of the Constitution and the Public Protector Act. And that's because sections 182 and 193 of the Constitution sets out this unique role that the Public Protector plays in our constitutional dispensation and the requirements to hold such office. Also relevant would be section 195 of the Constitution, which sets out the principles of public administration. So when the committee starts unpacking the evidence, it will be necessary at that stage to first have a briefing on the role of the PP, as it will directly inform whether her conduct meets the threshold for incompetence and misconduct. So in other words, members would need to acquaint themselves with the standard of conduct that is required from a person holding this office. In respect of the removal rules, those rules were adopted by the Assembly on 3rd December 2019. They define the terms incapacity, incompetence, and misconduct, and they provide the broad procedure to be followed. Firstly, the tabling of the substantive motion with evidence, the sifting mechanism by the independent panel to establish if there's prima facie evidence, and then this committee process to conduct an inquiry if the Assembly so determines, which in this case it has. From the Constitution and the rules, whilst they may not be prescriptive, they don't tell the committee how to perform its task. And this, Chair, is with good reason. The rules are not unique to the Office of the Public Protector. nor are they drafted to particularly deal with this motion. The same removal rules are going to apply to any other Chapter 9 head in respect of whom a motion for removal is brought. And of course, the basis for removal will differ greatly from one Chapter 9 head to another, and even from different heads who may occupy the same position. Thus, it's left to the committee to determine, with due regard to the nature of the charges and the specifics of the matter, how it will determine its working arrangements going forward. However, whilst the rules and the Constitution are not prescriptive in terms of how the process unfolds from this point, they do provide the outline of the steps to be followed for removal, and more importantly, the fundamental legal principles that must underpin the work of this committee. It's these principles that will need to inform every decision of the committee. I've termed them golden rules, and this is my own term that I've coined. And these golden rules are, in effect, the blueprint of the process. They are in place to ensure that the process is fair, that it's balanced, and that it's beyond reproach. The first rule is that this process is a constitutional process. And Chair, I make pains here to emphasize that this committee is not conducting a criminal inquiry, nor should it be seen to be such. This is not a judicial process, and it's not a litigious process. As such, the rules that would apply to criminal processes, such as evidentiary burdens, admissibility of evidence, and so on, don't find effect in our process now. They of no application here. The process is instead ultimately an oversight process. Indeed, it does have a political element in that it will culminate in a decision by the Assembly, which of course consists of members of political parties. Thus, notwithstanding that we may use terms such as witnesses, evidence, and even charges, I must remind members that we're not here to ascertain guilt or innocence. The aim is simply to determine whether there are grounds for removal on the basis of fact and law. The failure to establish those grounds means that there can be no basis in law for removal. Thus, this will emphasize later when I deal with rationality. But in short, the process that we are going to follow must be an inquisitorial process rather than an accusatorial process. This brings me, Chair, to the second rule of fairness. The rules require that the matter be conducted in a reasonable and procedurally fair manner and within a reasonable time. Also, very importantly, that the public protector must be afforded the opportunity to be heard in her defence. And as indicated... Chair, may I continue?
Go ahead, Fatima.
As I've indicated, the rules don't prescribe timeframes, the order of proceedings, which step must be taken first, and so on. These are the working methods of the committee, and they must be determined within this parameter of fairness and reasonableness. What would be fair and reasonable in one context may not be so in a different context. The third rule is that of rationality. The decision-making process that the committee is going to follow must be rational because the committee is exercising a public power. The NA needs to make its own assessment on whether the PP has misconducted herself or is incompetent as alleged, with due regard to the evidence and the information before it. So in other words, there is no rubber stamping or absolute reliance on the panel report. As I've indicated, the purpose of that was to allow for sifting to ensure that the Assembly does not proceed with a matter that is devoid of merit from the outset. So the panel has found that there was prima facie evidence of misconduct and incompetence, but it now falls to this committee to carefully consider and engage with the information before it to determine if in fact this is the case or not. In other words, members must approach this process with an open mind and a willingness to reach conclusions regardless of any personal persuasions. We can move to the next slide, please, Ms. Ngoma. Chair, we now turn broadly to the purpose, scope, and objective of this inquiry. The objective of this committee process is to establish the veracity of the charges by determining whether the PP has misconducted herself and or is competent as alleged. The scope is very narrow. It is limited to the motion itself and does not include conduct that does not relate to those charges. And it's this scope, Chair, that distinguishes this in a sense from other oversight processes. Because of the very serious implications of this process, it follows that it can't be open-ended. Often in our ordinary oversight processes, we take a more organic approach. So a committee will deal with issues broadly, and then it may zone in on particular aspects or inquire on new things that come to light as it proceeds with its oversight. In this process, Chapter 9 heads must be able to respond to clearly articulated allegations, and they shouldn't, as it were, be caught unaware or in a position where they're not able to respond and defend their conduct. Hence, the limitations on the scope. The purpose of this entire process ultimately is for this committee to report to the Assembly, and the rules state that that report must contain both findings and recommendations with reasons. And that inclusion of reasons speaks to that golden rule of rationality. And the committee will achieve this by assessing the charges in the motion against the evidence contained in the motion. In addition to that, the response by the public protector and any other relevant information that may come before the committee. In terms of the structure of the inquiry, I've now explained at some length that the rules and constitution are not prescriptive as to the working arrangements and methods that the committee must adopt to achieve the purpose and meet the objectives. Rather, they provide a framework which is general and applicable to all Chapter 9 heads. So these matters must be determined by the committee, subject to these golden rules of fairness and rationality, and with due regard to the nature of the proceedings. The committee should adopt a terms of reference, therefore, to agree on how this inquiry is to be conducted from this point forward. And issues such as public participation, the format of the inquiry, how the committee will deal with evidence, how it will afford the public protector a reasonable opportunity for audi, must now all be determined subject to the rules. And the committee is, of course, at liberty to address any other matter that it feels requires special attention in these terms of reference. Chair, I'm now going to go through some of those matters that we are of the view should be included in the terms of reference. The first is public participation. Section 59 of the Constitution dictates that the Assembly must facilitate public involvement in its committee processes, and that wouldn't be limited to merely the lawmaking processes, but it speaks to committee processes generally. The rules of Parliament are not prescriptive when it comes to how public participation must unfold, but the courts have made it clear that a reasonable opportunity must be given. And of course, in determining reasonableness, we have to take into account the nature of this process. And a removal process differs very much from a legislative process. And the committee should certainly not be seized with opinion and sentiment on what the competency of the public protector is. And by way of example, Chair, we know that there might be legislation heading Parliament's way dealing with the legalization of polyandry, which is the right of women to take more than one husband. It's not something that I am going to, an opportunity that I will avail if Parliament passes such a law. But one can already see that a bill of that nature is going to draw extensive public interest, and not just by persons who are able to input on the constitutionality or the legal aspects of such a bill, but people who merely wish to air their views in support or against such a development in the law. Now, in this case, in that case, the public participation process will be very wide, and the relevant committee can be expected to hear policy positions from a broad range of interested persons. In this matter, that sort of participation where people are expressing themselves on their personal views on a matter is not relevant. Whether someone likes or dislikes a Chapter 9 head, whether they believe that that person has done a good job or hasn't done a good job is in fact irrelevant for this committee. That sort of opinion and sentiment is not going to help the committee to achieve its purpose of determining whether there is misconduct or incompetence. So it would be necessary that any public participation process is limited and to persons and organizations who can meaningfully contribute to this fact-finding process, either because of their involvement in a matter where the PP's conduct is in question or their ability to share information that can assist the committee in reaching its finding. It falls to the committee to determine the manner in which it will facilitate public participation. This may include written participation, oral submissions by invitation, or a combination of those two. Our advice, Jen, and this again is our advice, but the committee is at liberty to decide what it feels best, is that the call for submissions can take the form of an invitation on Parliament's various social media platforms and be limited in terms of scope, as I've suggested earlier. The matter has gained increasing traction in the media and is already receiving wide coverage, and a period of about 3 weeks would be sufficient in our view. The second aspect of public participation speaks to the openness of meetings. The default position in Parliament is that all meetings are conducted in open unless there's compelling reasons for closure of a meeting, and those reasons outweigh the public interest in the matter. So, of course, the de facto position must be that all of these meetings are open, and we also have the view that all of the meetings should be streamed on the YouTube channel to ensure that the public is able to follow this very important process. And then in terms of documents that the committee will be seized with whilst conducting the process, we are of the view that these should be made available to the public unless there are very strong reasons in law as to why those documents are legally privileged. Okay, we can move to the next slide, please, Ms. Ngoma. Chair, this brings me to the very important aspect of the format that the committee must adopt, or that it will adopt to deal with the matter going forward. But before I begin with this, I think it's just important that I give the committee a brief snapshot of the documents already before the committee. This is just to show the magnitude of the matter that is being dealt with, and that may assist the committee in informing which format it chooses to follow. At present, the record is in excess of 10,000 pages. The motion consists of 4 main charges with a number of sub-charges related to each main charge. And then we also have the panel report now, which runs to approximately 119 pages. In addition to this, the committee will still receive representations from the public protector, and presumably will also receive other information during the course of the proceedings. So we can see that there is quite a bit of material that would need to be considered. So an important aspect now is, what is the format that the committee is going to adopt? In other words, how does the committee intend to gather evidence and then proceed to consider that evidence? And this could conceivably take various forms, provided that whichever form the committee chooses, it does so within the confines of those golden rules. So I've listed 3 very broad options, but there could, of course, be many variations that the committee may want to consider. And we've merely done this just to offer some scenarios and the risks attached. The first, which is the slide that we're currently on, is the use of an external evidence leader. Members will be aware that there have been inquiries in the past in which an evidence leader has been used, a recent example being the ESCOM inquiry. In such an option, the evidence leader bears the overall responsibility of presenting the evidence to the committee, and then also putting questions to witnesses and the public protector. The evidence leader, however, is not a prosecutor, and his or her presence will not in any way limit the right of members to ask questions. This, however, is a high-risk approach. The inquiry, firstly, is not quasi-judicial, and the use of the evidence leader creates the risk that the process takes on characteristics of an adversarial process. And there is the concern that an evidence leader may be seen as a prosecutor of sorts. And as I mentioned earlier, this is not a criminal process, and we must be careful to steer away from a process that creates such an impression. It may be impractical in as far as the committee needs to place a reliance on the availability of an evidence leader. Then, importantly, the process may be compromised if the committee is seen to be delegating its constitutional responsibilities. Members must not be seen to be relinquishing their powers to third parties, because the Constitution empowers members of the Assembly to maintain oversight rather than third parties. And ideally, members should be leading and directing oversight processes as per the constitutional mandate. This is not to say that the option is not feasible. It is possible for the option to be very carefully managed via tight terms of reference that clearly articulates what the role of this evidence leader is. Option 2 would be a member-led process with internal support. This would be similar to the way parliamentary committees conduct their ordinary oversight processes, where the chairperson guides proceedings and members are allowed to participate to the extent they wish or as agreed to by the committee in advance where there are time constraints. The committee would be supported by an internal team of legal advisors, content advisors, researchers, and support staff. These persons have already been identified too. The risk here is that the volume of evidence and the size of the committee may lead to the process becoming a little bit unfocused and difficult to manage. This is, as I understand it, the first time that we have a committee of this size. It will possibly require additional time for the study of all documents. And this is not to say, though, that this sort of format can't be managed. We can certainly enlist support staff to prepare guiding questions for members and to assist members in unpacking evidence. And it's also possible for us to split focus areas amongst members, as is done in SCOPA. In SCOPA, generally what happens is that particular members will be requested to prepare on certain areas, and they then lead the process, and other members then follow freely thereafter. The third option, Chair, is to have a member-led process, but one where not only have internal support, but also specialized external support. And this would be a hybrid approach where the process has this external forensic support to assist the committee to unpack the evidence. And in this scenario, the role played by that external support person will be more limited than compared to a pure evidence leader, as indicated in the first option. The exact role of this person would need to be determined by the committee, but by way of example, such a resource may provide a summary to the committee on each charge, a summary of the related evidence, assist the committee in identifying issues that require further probing, and then also assisting the committee with the formulation of questions. And Chair, at this moment, I must just mention that in terms of formulating questions in advance, if this approach is taken, or even the approach where staff assist with the formulation of questions, there's no reason why these questions cannot be shared with the public protector in advance in order to allow her an opportunity to properly prepare. In this scenario, members retain the lead. They are actively involved in the process, and members can determine amongst themselves again if they also want to have some element
as modalities are being figured out in the process to determine the unfitness of the public protector, Busisiwe Mkhwebane, to hold office. And our question of the day is related to that process. And we were asking you, are you engaging with that process? And if you are, what are your thoughts? We will be taking a look at a few tweets right now. Let's see what you have to say. Gift Pearl and Gerald says, I don't think she's definitely worthy of holding office of the public protector. She went in there like being deployed as a pawn, and she went too far like a self-created queen. She can't even set some of the records straight. She and them thought she can be fit, but they aren't. You see, you are commenting on the merits of the case, but what we're actually asking you if you are engaging with the process. The process today is on legal aspects of the Section 194 inquiry into the removal from office of the public protector. But Lokshan Balo is saying she's the right person to hold the office. This is just a political issue. Our judiciary is captured. But what are your thoughts about the process? Mkhwebane saying she has lost many cases. She's wasting state funds. Zakhele Pangisa says, not at all. Let the public protector do her job without fear or favor. And Da Vinci saying, morning days red, clearly the public protector should step down. As the title public protector, she failed to protect the public of South Africa and focus entirely on the political issues not related to protecting citizens. If we had someone who executed the public protector duties, we may have been spared the rioting. I really appreciate your interaction with the question today, but I think people are already rushing into the merits of the process itself, whereas we're saying the process now of determining the legal standing of it and how it should be constituted. Are you engaging with that process? Continue to talk to us at @theagenda_SABC.